Thanks for staying with us. Now, legislation isn't enough to help employees enforce their right to equal pay for equal work. That's according to a study by Stellenbosch Business School. This despite South Africa's comprehensive anti-discrimination legislation being considered among the most progressive in the world. The study comes ahead of International Equal Pay Day on Sunday. To unpack this and more, I'm joined by Professor Anita Bosch, who's from Stellenbosch Business School, Research Chair, Women at Work. Thank you so much for your time, Prof. We do appreciate it. I always say when we have these discussions about equal pay for equal work and how much discrimination people in the workplace face, how we're still having this discussion in 2022 is completely mind-boggling. But it seems this is still a serious problem. Tell us more.
Well, the study that we did was based on case law, and we looked at 21 years worth of cases that actually got to the labor court. We wanted to understand whether the progressive legislation aids people to actually win cases, and we found that more than 80% of the cases were unsuccessful, and you know, that was actually quite a shocking result, and what we see is that there's often misunderstanding in terms of bringing these cases, especially to the labor court.
Perhaps tell us, you say 80% of the cases were unsuccessful, and you allude to the fact that this is quite a shocking result, and I would say the same. But why were they unsuccessful? What were the reasons for that?
There's most probably one of the first reasons is that there's a misunderstanding about the difference between discrimination and differentiation, that in our law and in our common practice, that there can be differences between employees' pay at the same employer, and that there are even grounds on which these differences can occur. So often when these cases are brought, the individuals that feel aggrieved may not be aware of these points of difference, for instance, based on seniority, tenure, skills level, qualification, and so forth. And for you to bring a case that's based on discrimination, it must be about differential treatment that is prejudicial in nature or denigrating, something that deals with your human rights as such. And often there's a misunderstanding between these two issues. Then furthermore, these cases are usually quite complex also to deal with, and often the people that bring the cases to the courts are not well equipped in understanding exactly what the procedural issues are that they need to deal with, and then substantively what they actually need to prove.
Certainly. So it's obviously a lot more complex than we thought when it comes to being able to prove that there is discrimination when it comes to equal pay for equal work. And it's going to link to my next question. Women, majority of women in this country are overlooked often when it comes to promotions, but also when it comes to payment and the different ranks. I'm sure this is something that's also come up in your research. If you could maybe just tell us a little bit more about what you found when it comes to women and how they are paid.
Well, women's pay has been in the media for quite some time now, and there's quite a bit of focus on that. I think what's interesting about these studies of discrimination in general is that the cases that we're able to view are but a tip of the iceberg. In fact, there are many cases in the last financial or not financial year, from April until January this year, in the Commission for Employment Equity report shows that there's close on 400 cases around pay discrimination that reached the CCMA. And it's unclear whether any of those, what the percentage were that were successful or not. But often discrimination happens, and especially at very senior levels, and people know about it, take it up with their employer, and then are very concerned about their reputation. And so those cases never get to the labor courts because then it becomes public knowledge. So either people resign or there's some type of settlement that happens between the parties in order to deal with discrimination.
Are you able to tell us from your research if the situation is getting any better or if it's getting worse, and perhaps some solutions to this? Because it's great to show us what the problem is, but what's the actual solution?
Yes, so what we're suggesting in our article, there's a number of mechanisms that have to be strengthened. And the one big take is that the legislation is really fantastic if we compare it to other African countries, for instance. But we should note that we can't rest on our laurels just because we have the legislation. So the most important thing is for people to be informed, and this is why we often speak about this topic, about what their rights are. For you to understand the difference between discrimination and differentiation, and there are public reports available, some of which on our business school's website for free download. And then the other thing is to consider, for instance, how union representatives are trained to be able to support their membership, because most of the cases that reach the labor courts are the lower level paid individuals where there often is some type of union representation. So some of those reps definitely have to be trained differently. And then with the making public of the fact that we have this legislation and making employers aware of the fact that they really need to look and understand, go back and have a look at why you pay people differently and what your reasons are, and whether those reasons really can be substantiated or perhaps are just a historical fact that has developed over time. That is something that employers certainly must look at and are mandated by the Employment Equity Act to ensure that they eradicate any forms of that discrimination.
Okay, great. Thank you for that very insightful conversation. We do appreciate your time this evening. That was Professor Anita Bosch from Stellenbosch Business School.